Yes, yes, that's true. There are some changes, but nothing to worry. We've been receiving number of calls in the last couple of days about the changes happened from the 7th of December on the SID visa, which is from the 482 subclass work permit visa. Many of you are very much concerned whether you are already working in Australia under the 482 subclass visa, or you are in the process of applying for Australia either for a work permit or permanent residency. The new rule, is it getting affected on your chances to get a permanent residency or a 482? Today, we're going to talk about exactly what your queries are. That means hospitality sector, the number of trades, and what are the changes happens in the new visa. Let's get to the video. As you are aware, from the 7th of December in the new rule, the SID visa has number of trades and occupations added in the hospitality, which is a very surprise for many of us and many of you as well. One such thing is, earlier at the 186 employer nomination scheme direct entry, only the chefs were there. Obviously the cooks were not on the list. Especially when people are already working in Australia and say that you are working for the last couple of years, and then you are under the cook category and your employer is not elevating you to a chef, you may be worried that, or earlier there was a concern that you couldn't apply for 186 or other visas as well to become a permanent resident. But now that worry is gone. That's a great news. Even if you are in a cook category, now in the new rule, you are eligible to apply for 186. So you don't need to be concerned. Either the same employer can nominate you for a 186 direct entry, or you can able to negotiate with another employer who is able to support you for a 186 visa, which is a great news. And what is more interesting is, now look at what are the other trades has been added into the list. Now we have cooks, we have bakers and pastry. Earlier there was not an option. If you are a baker and pastry and you're limited to work on 482 visa and keep extending it, now you can apply for permanent residency after you work for a couple of years, or even you can find an employer, you can able to get into direct 186 as well. And butchers have added. And quite interestingly, the hotel managers also added. So if you are an accommodation manager, you have an experience in front of house on accommodation or managing a hotel or a motel in a general manager category, you are now eligible, which is a fantastic news as well. And another important concern is people who are currently working in Australia under 482 as restaurant managers, whether they are eligible to apply for a permanent residency pathway. Now, the new rule doesn't have the restaurant managers, which means there is no more new application under the 482 as restaurant managers as well as for 186 as well. But if you are already there, either your application is in the pipeline of 482 or you are already working in Australia on 482, you are coming under the old regime of the rules, which means you are exempted to apply for 186, which is also a great news. So if you are already in Australia, if you're working as a restaurant manager, no need to panic. You are eligible, so you keep working and you keep continuing doing the good job with an employer, and at some point of time you can request them to sponsor you to take you into the next level as a pathway to the permanent residency. And there is a question comes in, what about people who wants to start the process, who are already in the process of, say for an example, skill assessment as a restaurant manager? Unfortunately, the restaurant manager is not on the list, which means you need to look at the detailed job description. So that means you won't be able to apply for a 482 or a 186, you haven't started the process or you are not in the pipeline. But there are options. Say for an example, if you look at the hospitality industry, it's known for multitasking, which means you may be given as a designation as a restaurant manager, but your job description and your roles and responsibility is a key. Even in the past, many times what happens, they move from one department to the other department. So if you have experience in the reservations and the front of house, still you should be able to justify to the immigration department that you are a hotel manager, and you have to provide the evidence that you have done in the past so that you can able to satisfy the requirement of the new visa regulation. So there is a way where we are able to professionally approach each and every application and see that what best we could do and advise then how we can able to get that application through. That is a very key in the process for Australia, either it's for 482 or the 186 direct entry stream. And if you have any questions in your mind, whether you are eligible for certain occupations, the best thing to do is start your skill assessment process. You need to approach your skill assessment body and make yourself skill assessed, because if the skill assessment body certify you under specific occupations, and that's going to be the final one. So that means you don't need to worry about whether you belong to that category or not. Another important point that we have noticed in the new change is that in number of occupations, the required experience has been brought down. Even in some cases, just 1 year is good enough. However, one of the mandatory requirement at this stage for the SID visas, same as 482 or 186 or 189, 190 visas, the requirement is a skill assessment. And in the skill assessment, there are specific mandatory requirements which you need to satisfy. For an example, even if the visa is asking for a 1 year experience, if the skill assessment is asking for a 3 year, still you need to have a 3 year requirement. I'm sure after this change, there will be some update happening at the TRA and other skill assessment bodies about the revision, maybe on the minimum requirement, because the skill assessment goes through the Australian Quality Training Framework requirement. So there's a bit of complications, it's all interconnected, and how they're going to address this particular change. However, at this stage, if you are going through a skill assessment, I would strongly recommend you go through first on the skill assessment requirement and make yourself successfully skill assessed and get your required English, and then you need to look out for the immigration rules, even the current changes, whatever it's happening. If you find this video is helpful to you, and there are a number of other videos also we have posted in recent times, mainly for the changes happens on the 7th of December. I'm sure those are the videos also will be of an interest to you. Please do watch, and I look forward to see you with another update very shortly, and good luck.